breaches are occurring, all that makes no sense. What you need to do is have the full capacity of understanding your policies, your procedures, your training, your awareness, your documentation, but also your breaches and what happens if in fact there becomes a breach. That's what we're going to discuss today, the breach notification rule and the enforcement rule. The information provided, once again, as always, I hate to be so ongoing about this, is even though I am an attorney, this is not legal advice, this is just educational information for the same purposes. All the information too provided today, as always, is updated. It is updated to reflect the omnibus rule, which went into effect March 26, requires your full compliance within 2 months by September 23rd, 2013. Also, the information provided today, just as our last seminars, is a basic condensed version of the enforcement rule and the breach notification rule. There may be some exceptions to the rules that are not addressed today. Please, please, please always speak to your legal professional, in-house legal counsel, or in the alternative, your compliance professional. If you do have other questions, you can always pick up the phone and call me. You know that. Before we start, some brief words about compliance. I hate to sound like a broken record, but as Peter would tell you if he was here right now, HIPAA compliance is not a suggestion, it is a commandment. This is mandatory compliance if you are a covered entity or, in the alternative, a business associate. HIPAA compliance is never complete, it's ongoing. I give you some examples here showing you risk management, review and modify your policies and procedures, train your workforce, conduct your risk analysis. This is all necessary. They're just examples. Imagine that diagram was spinning in a continuous manner. Maybe for practicality purposes, you have your HIPAA compliance program thought as a puzzle. We're going to add today more pieces to that puzzle that you already have for your HIPAA compliance program. The breach notification portion of your puzzle and the enforcement rule. Just keep in mind though, if just one piece of your HIPAA compliance puzzle is missing, your HIPAA compliance program may be incomplete. Let's start with the breach notification rule and enforcement rule. The abbreviations are similar. If you've been attending the seminars, you've seen them: covered entity, business associate agreement, electronic protected health information, individually identifiable health information, notice of privacy practices, and protected health information. Just as a review, protected health information is individually identifiable health information that's transmitted by electronic media, maintained in electronic media, or transmitted or maintained in any other form or medium, i.e. paper. There are some exceptions and exclusions to individual identifiable health information. IIHI, demographic information collected from an individual, created, received by a healthcare provider, gives you all the demonstration of what individual identifiable health information. Obviously, if you are here, you are aware of individually identifiable health information and protected health information. Let's start now with the breach notification rule. The first thing I want to address are the breaches, and they should raise that red alarm, that signal in your head that, oh, something has happened. Usually what I get the phone call is, Chris, we had an incident. So let's talk about when is an incident breach. This is what I get on the phone. Hey, Chris, how are you? Well, we had an incident at our practice. A patient's protected health information was disclosed to a third party who is not a business associate. Here's a question I always get. What do we do? Very broad, basic stroke of the pen. Let's first determine if this is a breach. Obviously, if this is a real-life scenario, I'm going to have you contact the CEO. I'm going to get you all the important people together first. You're going to make the determinations. But we are going to determine if the incident is classified as a breach under HIPAA. You'll have your legal department. You'll have your security officer, privacy officer. You might even have your own separate compliance officer. And you're all going to sit down. Well, how do we determine, Chris, if the incident was a breach under HIPAA? The thing I'm going to ask you is, does it meet the definition of a breach? According to HIPAA, and these are in your slides, you're going to have these, your copies of the slides, a breach means the acquisition, access, use, or disclosure of protected health information in a manner not permitted under HIPAA's privacy rule, which compromises the security or privacy of the protected health information. You do have some important exclusions to that definition. I'm going to go over those right now. You have three pretty unique exclusions for breach, what a breach is not. A breach is not any unintentional acquisition, access, use, or disclosure of protected health information by a workforce member or a person acting under the authority of a covered entity or a business associate if it was made or used in good faith and within the scope of authority and does not result in further use or disclosure in a manner not permitted under the privacy rule. Somebody within your workforce sees something that they don't have permission to see, but it was unintentional. It wasn't like they were trying to commit fraud. They just went over, they went to grab something, they saw something on the computer screen. Not a breach. Also, any inadvertent disclosure by a person who is authorized to access PHI, so I can go and access PHI at the covered entity, or if I'm a business associate, at the business associate's business, to another person authorized to access PHI at the same entity. I bring over somebody's medical records to you. Here you go, you had a patient. Here's their medical records. I'm going to go to lunch. You open them up. You're dealing with Mary Smith. I brought you John Doe's information, not a breach. Once again, it's inadvertent. First one was unintentional. This one was inadvertent. You see something you shouldn't have seen. Again, you're within the covered entity. You know that you are not committing a fraudulent act here. This is just unintentional or inadvertent. What about a disclosure of PHI where a covered entity or business associate has a really good faith belief that an unauthorized person to whom the disclosure was made would not reasonably have been able to retain such information? I'm at your front window. I'm saying goodbye to the patient. It's my job to give them information that the doctor wants them to have. Their bill, description of the services rendered, prescription, everything like that. In the midst of all the confusion, I give them inadvertently George's protected health information, whatever he had, the treatment he had done, whatever it was. They grab it. Thank you. We're walking out. Hey, I'm going away, going to Rhode Island. As you're me being the patient now is walking out the door, you see that I have the wrong information. You notice it, you run, you get the patient, you say, I'm so sorry, may I have that back, please? Probably not a breach because the disclosure, and I gave you George's information, it wasn't yours. I gave you somebody else's information. The disclosure was made, would not reasonably have been able to retain such information. If I just grabbed it and I'm walking out, what's the likelihood I looked at George Berlez's information? Very, very minimal. So that is an exclusion. There are some caveats, though. With any of the three exclusions that you see here, you must document why the impermissible use or disclosure falls under one of the three exclusions. So even though it happened, even though it's not a breach, you always want to just document. That's one thing I really, really try to stress to all of the participants in these seminars. Document, document, document. Even though it's not a breach, because it falls within the exclusion, you still have to document it. The reason being is because somebody may come later on and say, hey, I took George's stuff. They came running after me. Yes, that happened on this date. They turned around. They did not view it. We saw they did not view it. We picked it up before they ever said anything, and it was clean.
So where does that documentation go?
It goes in your HIPAA policies, practices, procedures, all of your manuals.
So make a dated entry in that?
Absolutely. You can. You can also have a separate book next to your policies and procedures that say breach exceptions or incidents, you may want to call it. Whatever it is, however you want to document, retain it. It could be electronic. It can be, stored somewhere. Wherever you keep it, I would have it readily accessible, because if in fact you get a letter, OCR is coming in, or in the alternative, Department of HHS is coming, whoever's going to come in and audit you or investigate you, there you go. The thing that they're complaining about, this is what happened, word for word. Here it is. They're going to have their word against yours. You're going to have all the documentation. Again, the document, document, document. By the way, the burden of proof is on you or the business associate showing why an incident was not a breach. I'm going to go through this, but I'll tell you in advance, the way the government looks at it, if there's an incident, they believe it is a breach. It's guilty until proven different. Well, you say to me, Chris, you know what? You went through that documentation, or I'm sorry, you went through the exceptions with me, you went through the definition. I'll be honest with you, the PHI was disclosed in a manner not permitted under HIPAA's privacy rule, and the incident does not fall under any of the exclusions. Now what? Okay, let's go back, I would tell you, and see if that incident compromised the security or privacy of the protected health information. Well, how do we do that? What I would tell you is, we're now going to conduct a risk assessment. That's not a risk analysis. This is a risk assessment of the disclosure. What is a risk assessment? The government has 4 factors that you need to go through for any incident, and they are required. A breach risk assessment is essentially an objective standard test consisting of 4 factors to determine if there's a low probability. Now, this is new. Starting in March, this is new from the omnibus rule. It used to be that risk of harm standard. No more. Low probability standard. You have to now determine if there's a low probability that the unsecured protected health information in question has been compromised. If all of you are looking at your slides right now, please, please, please circle this. If you have a red pen, if you have a highlighter, circle the word unsecured, highlight it. We're going to come back to that, and it's going to be very brief, but I want to show you why. From here on forward, whenever you see this word unsecured in any of the slides, I want you to circle it and highlight it, and I'll show you why when we come back. Here is the risk assessment test. These are the 4 factors. These 4 factors are mandatory. You must go through each one of these. You may add more factors of your own, but you must include these 4. Except as provided within these exceptions right here that we went over, an acquisition, an access, a use or disclosure of PHI in a manner not permitted under, let's say the privacy rule, but let's call it HIPAA, is presumed to be a breach unless the covered entity or business associate is applicable, demonstrates that there's a low probability that the protected health information has been compromised based on a risk assessment of at least all the following 4 factors. I am going to go through each one of those factors with you right now. The first one, the nature and extent of the PHI involved, including the types of identifiers and the likelihood of re-identification. What type of PHI was involved, I'm going to ask you. Let's say the incident was the loss of a laptop. My first question is going to be, what was on that laptop? You're going to tell me everything. When I hear the word everything, I'm going to the next factor. But if you didn't tell me everything, let's look at this. Did the disclosure I'm going to ask you involve information of a more sensitive nature? What do you mean by sensitive, Chris? Well, do they have credit card information, social security information, or other information increasing the risk of identity theft or fraud? Yeah. Let me also ask you this. Did the disclosure involve sensitive clinical information, treatment plan, diagnosis? Oh yeah, absolutely. Can the PHI disclosed be re-identified based on the context, just as it is? Yeah. Then you may say, probably not. Well, let me ask you this then. I'll go even further. How about the ability to link that information with other available information that I can get on the internet? Worst thing about the internet, nothing is private anymore. You can find anything about anybody, right? All you got to do is hit Google search. So I can take just a sub-portion of that information that you lost, and I can take it and link it with information that I have that I can find online. I can connect the two, and there's probably going to be identity theft. So we now have the first factor. That's pretty sensitive information. Let's look at the second factor. The unauthorized person who used the PHI or to whom the disclosure was made. If I stole that laptop and you don't know who I am, you don't know who I am, right? You don't know the unauthorized person. So your answer there is, whew, it's stolen. We don't know who took it. Okay, so we're going to move to the next factor. However, what if in fact the unauthorized person who used the PHI or to whom the disclosure was made is not a person of a theft, is not unknown, but rather is known? This is important. Consider whether the unauthorized person who received the PHI has obligations to protect the privacy and security of the PHI. So, we have PHI involved. Let's say it was sending a fax over to another office, but you inadvertently hit a wrong number and the fax went to another doctor's office. Whew, I would say. Because that doctor's office also has to comply with HIPAA. It's not their patient, but they got to comply with HIPAA. For example, if PHI is impermissibly disclosed to another entity obligated to abide by HIPAA, there may be a lower probability that the PHI has been compromised, because you're going to have somebody on the other end of the fax going, we don't have a client named John Smith, and this is coming from this doctor's office. Okay, we now have very sensitive information, but the person who received it also has a duty under HIPAA. Now we still have to go to the third factor. Was the PHI actually acquired or viewed? Let's take a look at this in two scenarios. This is the one I'm giving you right here. Let's take a look at this example. Medical group, and this happens all the time. Medical group permits certain workforce members to take home laptop computers to work at home. One laptop is stolen during a home invasion. The laptop is later recovered by the local police and returned to the medical group. That medical group was very good. They contacted a forensic analysis provider. They provided and performed a forensic analysis on that laptop, and they said there is absolutely no way anything was viewed. Whew, another, phew. In that case, the medical group could determine, based on the independent third-party forensic analysis, that the PHI was not actually acquired by an unauthorized individual, even though that opportunity exists. And again, please have those done forensically. Third parties. Don't do them yourself. Don't open it up. Say, well, no one looks like they opened the password. Have it done by a third party. This all has to be documented. However, when you're sending the PHI over to another doctor's office, of course they're going to look at it, because how would they know that that's not their patient? So of course it's viewed. But who's it viewed by? An entity that is being controlled by the HIPAA rules. So again, I'm going a little more like, whew. Fourth, the extent to which the risk to the PHI has been mitigated. You got a phone call from a doctor's office. Hey, we got your patient's information. This isn't our patient. Okay, can you please shred it? We already did. I'll tell you what. We'll send you something in writing showing that we, the wrong medical provider, shredded it. We'll attest anything we need us to do. As a matter of fact, if anybody calls you from HIPAA, here's my name and number. You're going to get all that information down, though obviously you want to document it. Hasn't been redistributed. I can promise you that. They'll tell you on the phone. Okay, that's fine. You want to mitigate the risk to the PHI, okay? You want to make sure that it's going to be destroyed. If you're dealing with another medical provider or someone else that has to deal with and provide with HIPAA, a business associate that is in the realm of medical field and also has to abide by HIPAA, breathe a sigh of relief, because they're going to know what to do. They're not going to, hopefully, go out, sell it, theft, anything of that sort. You run through those 4 factors. If you determine there's a low probability that the PHI, the security, privacy has been compromised, you're fine. Very low probability, you're fine. However, what I want each and every one of you to do, if you are building your own policies and procedures manual, take each one of these factors. Please state them clearly in your HIPAA policies manual to ensure that when evaluating the risk of an impermissible use or disclosure, all factors are considered and evaluated. All you need to do is for each factor, make it a separate page. Please, I'm a big fan of the tabs. Use those tabs in your books and your manuals. Have a tab that says breach, have a tab that says enforcement, have a tab that says training. Tabs, you can't have enough. And it also will help you in a time of crisis when your head is like, oh my God, what's going on? It allows you to be more calm and act a little bit more collected so you know what to do. And if an evaluation, once again, of all the 4 risk assessment factors fails to demonstrate that there's a low probability that the PHI has been compromised, then a breach has occurred, such as that laptop was stolen, had everything on there. I don't know. Anybody could have opened that up, looked at it. That's a breach. Breach notification is now required. We're going to go over breach notification as well. Keep in mind, whenever there's a breach notification, the breach is mandatory. That risk assessment is mandatory, like I said. However, if in fact you're so certain that, you know what, this was a breach, I know this stuff got disclosed, I don't want to go through the 4 factors, you can just jump to the provision of giving the notification. Breach notification. The PHI was disclosed by your medical practice in a manner not permitted by the privacy rule. After conducting a risk assessment, you determine that there's not a low probability that the PHI has been compromised. You must now provide notification of the breach. Who gets notification, though? Mandatory, the individuals affected by the breach, Secretary of Health and Human Services, possibly also the media. Notification shall, following the discovery of a breach of, here's what I want you to circle again, because this is important, unsecured protected health information. Notify each individual whose unsecured protected health information has been or is reasonably believed by the covered entity to have been accessed, acquired, used, or disclosed as a result of such breach. So here goes your notification. When is a breach treated as discovered? You should also have this in your manuals. For purposes of notification to individuals, the media, and the secretary, a breach shall be treated as discovered by the covered entity, if that is yourself or if you're a business associate, the first day on which such breach is known to the covered entity, or by exercising reasonable diligence would have been known. So someone comes to you, here's what happened. We got into the office, the window was broken, tapes were taken, boxes were stolen, boom, that's the first minute you know about it. It's known. What about those covered entities that sit there at their desk? I don't want to hear it. I don't want to know. I'll tell you what, you know when a breach occurs? When someone picks up the phone and tells me they found something. Don't run like that. Don't operate your business like that, because the way the government looks at it, it's discovered by you exercising reasonable diligence would have been known to the covered entity, meaning you want to make sure you take a proactive step. What are you doing to go and find to see if any breaches are occurring? You shall be deemed to have knowledge of a breach if such breach is known or by exercising reasonable diligence would have been known to any person other than the person obviously committing the breach who is a workforce member or agent of the covered entity. So you need to be proactive to find out whether or not there's stuff that is going out of your office that should not be going out of your office. Reasonable diligence is simple. The business care and prudence expected from a person seeking to satisfy a legal requirement under similar circumstances. Those are your legal requirements right there. The determination of whether a person acted with reasonable diligence is generally a factual one. Totality of the circumstances is what happened. Factors can be considered. Whether the covered entity or business associate took reasonable steps to learn of the breaches, again, being proactive. Whether there were indications of breaches that a person seeking to satisfy the rule would have investigated under similar circumstances. What that means there are red flags. If there is something going on in your practice that's raising your alertness and is raising a red flag, by all means, you are very, very in tune to your practice. If it raised your red flag, it raised it for a reason. Go on your gut instinct. Start to investigate what's going on. Notification time frame. When do you have to provide this notification to the secretary, to the media, to the individuals? Except as permitted by HIPAA for a delay of notification by law enforcement. Law enforcement comes in and notifies you that don't go sending this out right now. There's an investigation going on, and I'll go over that with you. You shall provide the required notification without unreasonable delay and in no case later than 60 calendar days after the discovery of a breach. Once again, we're going back to the discovery definition here. So the 60 days starts running pretty quickly. However, here's another caveat. You may find that waiting the 60 days to report, notify, is not reasonable. You may have to report and notify much sooner. And we'll go through why, but there may be reasons that if you delay, everybody's information is going to be out there. There's going to be identity theft going on, and they don't even know their stuff was stolen or breached. You may not be able to wait the 60 days. Again, the time period starts when the incident is first known, discovered. We showed you what the elements were, not when your investigation is complete. So, hey, the window was broken, something went on there. Okay, let's start. A couple weeks go down the road. Yeah, we found out something was stolen. All right, what do we have 60 days starting from today? No. Breach notification begins when the incident is first known, not when the investigation is over. You are expected to make the individual notification as soon as reasonably possible. Again, you have the 60 days, but as soon as reasonably possible, because they don't want patients' health information out there for identity theft, fraud, anything that can happen. The government's purpose is to protect the patient's protected health information. Why would law enforcement want to delay notification? There's a criminal investigation that could be impeded, or there could be damage to national security. But again, notification will be given you by law enforcement. Please, please, please keep anything that is documented by law enforcement. What is required to be included in your breach notification? I would take all these steps I would take all these factors right here of what needs to be included. Please, please put this in your HIPAA policies, practices, procedures, protocols manual. Put this in your manual because, again, if you do happen to have a breach, this is what exactly has to be put in there. And it goes through step by step exactly. A brief description of what happened, a description of the types of unsecured PHI, any steps that they should take, they being the people who are affected, to protect themselves, a brief description of what the covered entity involved is doing to investigate the breach, contact procedures for individuals to ask questions. Again, all this needs to be laid out internally by you. So in fact, when you do have a breach, and one thing I'm not going over is just the policies and the particulars, you're going to have a PR person. You want that face of your practice to be seen and viewed by, if in fact you have to contact the media, or in the alternative, the media is going to be contacting you probably if this is something that generates local interest. Who do you want to be representing your practice? It could be an outside PR firm, it could be somebody independent. Whoever you have, make sure they're very, very well spoken enough that they don't slip up when they're talking to the media or the news or anything of that sort, giving any sort of sound bites to the news, or in the alternative, if the people want to quote them in the newspaper or anything of that sort. Methods of individual notification: written notification by first-class mail to the individuals at the last known address of the individual, or if the individual agrees by electronic notice, you could send them email. All this has to be demonstrated, though, that notification was given. Again, default written notification, first-class mail. However, you may allow email, but there's the caveat before that they had already had to have agreed to receive the email. Next of kin for anybody who is deceased as well. Individual notification in limited circumstances. Again, limited circumstances is big here. You have a client that has chosen never to receive communications from your office with any written address or email address, only receive communications from you via phone, or they'll speak to you orally in person. You are permitted under HIPAA to telephone the individual to request that they come to your office and pick up the written breach notification from the provider directly. If they don't want to come, there gives you the example of what you can do as well, saying, look, we gave you the information, we'll give you all the information over the phone, you document and you inform the Department of Health and Human Services that they wish not to come in, they didn't want to get notification of the breach, because again, HHS wants to see that you gave notification to everyone involved. What happens if there just isn't enough current contact information to permit written notification? You can give substitute notice. Substitute notice is identified if there's 10 or fewer individuals, or there's 10 or more individuals, and again, that's in your slide as well, if you should see such a particular event. Additional notice in urgent situations: you may just have to get on the phone and start calling people immediately. That is fine, however, as long as you follow up with written notification. Again, why might it be immediate? Because you know that their information's out there, it could be stolen, identity theft. Here's where the media comes in. If you have a breach with 500 residents of a state or jurisdiction, in the same state, in the same jurisdiction, you have to give notification to the media. That's your key number, 500. Now you call me up and you say 300 of the people were in Vermont, 200 were in Connecticut. Which media do we contact? The answer is none. 500 residents of a state or a jurisdiction, that's your key trigger. Timeliness of notification, again, 60 calendar days. I wouldn't wait the 60 calendar days. Content and notification, the same that you're going to give the individuals, you're going to give to the media. But your triggering number is 500 within the state or jurisdiction. Media notice is in addition to individual notice and notice to the secretary, which we'll go over next. This is not a substitute for notice. So it's not like you could say, okay, I contacted the media, I'm not going to give individual notice, and I'm not going to contact the secretary, they can find out through the media. No, this is in addition to. However, notification to the secretary. You have 500 or more individuals. It doesn't matter what state they live in. They can be 500. 3 can live in Connecticut. 400. And 97 could be living in Vermont. You still have to let the secretary know, and you are going to be put up on their wall of shame on the website for the government. Less than 500 individuals, you still have to notify the secretary. However, it's not until 60 days after the end of the calendar year that it has happened, only for violations of 500 or less. 500 or more, you got to notify immediately the same time that you're notifying the individuals. But again, you're also going to be put up on that wall of shame. Business associates, make sure in your business associate agreement that your business associate knows that they have to tell you of any breaches they become aware of. Why? Because it's your duty to notify the secretary. Now, a covered entity may, in their business associate agreement, say, you know what, business associate, if there's a breach, I'll allow you to contact the secretary. You can delegate, so long as a covered entity delegates that responsibility to the business associate. Quite frankly, I don't know why you'd want to do that. I'm not saying that it's wrong. I just would rather handle that myself if I'm a covered entity. You can delegate that responsibility to a business associate. However, it is the ultimate responsibility by the covered entity to notify the secretary. Again, they have the same time as discovery. When is a breach discovered by a business associate? Same time frame. Same method as the covered entity. Please put that in your business associate agreement. Spell all this out. All you need to do in your business associate agreement, and we gave you the sample business associate agreement in one of your previous, I think during the Omnibus Rule seminar that we gave, add this information to it. Hold the business associate feet to the fire. Content of notification from a business associate to a covered entity. That business associate, again, you want to put this in your business associate agreement, you want everything and anything that involved that breach. Who, what, where, when, because you're going to have to provide that information to the secretary and to the individuals and to the media yourself. Perhaps the media, but if you do, you want all that information. The burden of proof is placed upon the covered entity and or the business associate. You are guilty until proven otherwise. Now again, guilty is a term I'm using very loosely here, but of course the government says if there's an incident, we're constituting it as a breach. Show us why it wasn't. Unsecured PHI. Here's why I wanted you to circle anytime you saw the word unsecured PHI. All of what I just went over could have been completely ignored if the information that was lost was secured. And secured within the variables mandated by HIPAA. PHI that is not rendered unusable, unreadable, or indecipherable to an unauthorized person through the use of technology or methodology specified by the Secretary in the guidance issued under the section, again here, this is the public law, this is the federal, is unsecured PHI. Therefore, if you have a breach and it involved unsecured PHI, or if you have an incident that involved unsecured PHI, it is a breach. However, if the PHI is encrypted, then no breach notification is required. Why? Because it couldn't be accessed, right? You can't use it, disclose it, view it, anything of that sort. Always, whenever you have the opportunity, it should be mandated within your policies and procedures that anything of electronic protected health information is encrypted. The problem becomes when you have paper and it's going around and it's not shredded, it's just sitting there, big problem. If you do use a shredding company, one of the things I was telling the previous group is I don't advocate, I don't have any affiliation, but I watched a very simple video on Shred It, and they show why they literally fray the sides of everything that they cut up because it makes it less readable or more difficult to ascertain what was being done. So maybe that's something that you might want to look into. If you're using a shredding company, find out how that shredding paper is done, how small is it done, what do they do with it after it is shredded, everything like that. Make sure you get certification or some sort of certificate that they shredded the documentation and it's not going to be, utilized for any other purposes. And find out that the trail, the paper trail, where is that shredding company going after they shred your documentation? One of the things I think that Shred It said is they take all the shredded paper for that day and literally scramble it together, making it even more difficult to try to find a variable to identify. Safe harbor provision. Here's what the government encourages you to do. Take advantage of the safe harbor provision of the breach notification rule by encrypting your protected health information. You do that, guess what? It's not going to be a breach. It's that simple. It's an easy way out if done properly and correctly. Okay, the enforcement role, this is where the government comes in. Investigations or reviews by the Secretary. If somebody files a complaint against you, there's going to be an investigation. Very, very possible there's going to be an investigation. The government can also do a review of you. Investigations by the Secretary. The Secretary will, this is new with the omnibus rule, this is new. The Secretary will investigate any complaint filed when a preliminary review of the facts indicates a possible violation due to willful neglect. We'll go over willful neglect. However, the Secretary may investigate any other complaint filed. Again, these are physical complaints that are filed, not something that they saw on the television. These are complaints that are filed. That's going to trigger an investigation. It's going to be a review of your policies, procedures, and practices. Get ready. Get your aspirin out because you're going to have a headache. They're going to go through everything. And the compliance reviews. The Secretary sees something on the news, that information got out, they can do a review on their own. They can also just do a review for any other reason, meaning if they want to and trigger an investigation via a complaint, they will. If they want to do a review of your practice because of a compliance review, they can. You're going to call me up, say, I just received a letter stating that we're being investigated for a complaint, or we got a letter from the department. The Secretary is saying they are going to conduct a compliance review. What are we required to do? My answer to you is comply and cooperate. Cooperation is required by HIPAA. This is not my suggestion. This is required by HIPAA. You must cooperate with the Secretary. If the Secretary undertakes an investigation or a compliance review, they're going to go through all of your books. By books, I mean your HIPAA compliance and your PHI. HIPAA compliance manuals. How do you cooperate with HHS? You permit access during normal business hours. However, the Secretary determines that there are circumstances that you're going to start destroying information before they can get there, they're going in at any time they want and without notice. imagine them busting down your doors. That's what they're going to do. If any information required of a covered entity or business associate is under the exclusive possession of another agency, institution, you have to identify that institution, agency to the secretary, and whether or not you made that you made attempts to get that information from them. They may also go over there and investigate as well, because if it's a business associate of yours, they have the right to be under the guidance of HIPAA, and the secretary will also utilize them in the investigation. Covered entity or business associate must provide records and compliance reports. Remember I was telling you from the previous seminars that you were here, always have your reports, your data, your retraining, anything that you do, your limited data sets, anything that you have control of reports over. When you did your updates, when you did your reporting, you may just have training, you may have your policies update. Whatever your records are and compliance reports, they're going to go through those, have those ready for them. The action regarding complaints and compliance reviews. This is what can happen. The secretary wants to resolve the matter by informal means. That's good. If an investigation of a complaint or compliance review indicates noncompliance, the secretary may attempt to reach a resolution of the matter satisfactorily to the secretary by informal means. What's an informal mean? You can demonstrate compliance or complete a corrective action plan or other arrangement, or even an agreement. If the matter is resolved by informal means, the secretary will inform you, and if it came from a complaint, they will inform the person who filed the complaint against you that it was done through informal means. What about if they resolve it and it's not through informal means? If the secretary finds that a civil money penalty should be imposed against you, they're going to inform you of such. They gave you the opportunity. They're going to inform you and provide you with an opportunity to submit written evidence of any mitigating factors or affirmative defenses for considerations. They asked you to do what they wanted you to do. You basically didn't do what they wanted you to do. Now they're going to up it a little bit. What about when no violation is found? That's beautiful, huh? After an investigation or compliance review, the secretary determines that further action is not warranted. The secretary will so inform the covered entity or business associate, and they'll also inform whoever filed the complaint against you. Meaning they went in, there were no violations, they're walking away, and you're very happy. However, what if we're starting to look at monetary penalties here? Secretary will impose civil money penalties upon a covered entity or business associate if it determines that the covered entity or business associate has violated administrative simplification provision. If the secretary determines that one or more covered entities or business associates were responsible, they're going to go after each one. Covered entity is liable for the common law of agency, for civil money penalties for a violation based on the act or omission of any agent of the covered entity, including a workforce member or a business associate. Also, a business associate is liable for the acts of their agents, i.e. their subcontractors. Amount of the civil money penalty. Let's say the violation involved you or a business associate not knowing of a violation, and by exercising reasonable diligence would not have known of the violation. Reasonable diligence is the business care and prudence expected from a person seeking to satisfy a legal requirement under the similar circumstances. Penalty for each violation, they're going to start at $100. They can go up to as far as $50,000. There is a cap at the end for the year. Maximum amount of penalty for an identical violation each year, $1.5 million. That's for an identical violation. That's just not for all violations combined. $1.5 for each identical. So that $1.5 can easily escalate. Amount of civil money penalties for violations due to reasonable cause. By the way, reasonable cause means an act or omission in which the covered entity or business associate knew, or by exercising reasonable diligence would have known, that the act or omission violated an administrative simplification provision, but in which the covered entity or business associate did not act in willful neglect. So it didn't rise to willful neglect, but it is reasonable cause of a violation. They're going to start at $1,000. They can go up to $50,000. Once again, for every identical violation per year, there's a max penalty of $1.5 million. Here's where we're now going to get into the big area, willful neglect. Let's say you have a violation of willful neglect. Willful neglect means a conscious, intentional failure or reckless indifference to the obligation to comply with the administrative simplification provision violated. But whatever it was that was done was corrected within 30 days. The government's going to thank you for that by saying, we're only going to hit you between $10,000 and $50,000, $1.5 million max for each identical. That's if you correct it within 30 days. Let's say you don't correct it within 30 days. they're going to start at 50,000. 10,000 is off the table, they go right up to 50,000. And they can go up to 1.5 per year, identical violation. Once again, that 30-day period for willful neglect begins on the first day the covered entity or business associate knew or by exercising reasonable diligence would have known of the violation. Once again, if it comes to your attention, but by exercising reasonable diligence you would have known earlier, there's that 30-day period, much earlier. Violations of identical requirements or a prohibition, once again, 1.5 million like I showed you for each identical violation. Factors considering determining the amount of a civil money penalty. I gave you a handout to show you the factors. The reason I put it in a handout is something you can just look over and review if you want to sit down and say, well, what are the factors they're going to utilize if they're going to zonk me? What are they going to hit me with? What are they also going to consider? So this way you have that information. Affirmative defenses. The secretary cannot, they may not impose a civil money penalty on you or a business associate for a violation if you or the business associate establishes to the satisfaction of the secretary that the violation A, was not due to willful neglect, and B, corrected either during the 30-day period or some other time that the secretary determines to be reasonable. Limitations. No action under HIPAA's enforcement rule may be entertained unless commenced by the secretary within 6 years from the date of the occurrence of the violation. That's the statute of limitations you may so generally hear of. Regardless if you are handling a breach or responding to an investigation, you could stop right there. Document, document, document. Always, always, always document. And if Peter was here, this is the one thing he loves seeing. He says when he looks out on the landscape is regardless of the size of your practice, the importance of an effective HIPAA compliance program is just too great to ignore. As always, please take advantage of this. If you have any HIPAA questions, call me anytime. Email me. Pick up the phone. I'm always there for you. I enjoy doing this, so please. It is a little bit dry. I do apologize. I hope I didn't bore you too much. And if you do have any questions, please ask now. Or again, if you want to wait till you're at the office, give me a call. All right?
I just have a
Yes.
question. To correct the violation, would need to notify the person and be sure that's met.
Well, you have to notify. That's not correcting the violation. Correcting the violation is going to the root of the infection, if you will. Cleaning it out. Okay, what did we do wrong? What could we do better? What did we not do? What should have we have done? You put it all in your policies and procedures. You're showing, basically think of it as a broken fixture. You fix it all up. The government's going to come. Is it sturdy? Yep, it's sturdy. Is it within code? It's within. You see, I'm being facetious,
Right.
but you want to make it very, very much corrected. All right. Thank you so much for coming. Thank you for battling the heat. I wish you a great weekend, maybe even a cooler one. So, that right? Thank you. Thank you again.
Thank you.
You're welcome.
Again, like Chris said, thank you, everyone.